All right, and welcome back. And in this video, we're looking at the section of the Shell chapter that talks about brand warfare. This is the second video in the 8-video sequence plus the welcome video. So I hope that this is helpful to you. And again, if you want me to broadcast from particular locations in the future, let me know. But for now, we're going to go to our classroom in the sky outside of Morkin. Okay, so this video will be a little longer than the others just because there's a little more content in this section. But what we're going to be talking about is brands and how brands fight against each other. So, but before we do that, we need to define what a brand is and why brands are important and why the legal system is so important to the value of a brand. We're also going to talk about the requirement to enforce a brand. So to enforce a trademark in particular, this is something that trademark owners need to do in order to protect their trademarks. And then we'll go through a few basics of trademarks. This is of course in the book, but I want to cover a few key legal concepts and make sure that we're all on the same page about what they mean. And then we'll look at 3 cases: Pepsi versus Coke, Windows versus Lindows, and Victoria's Secret versus Victor's Little Secret, which was a fun case. Okay, so first of all, what's a brand? Well, a brand is really just a trademark. It's a intellectual property that's an element of intellectual property that's associated with the product. So the cola in this Pepsi bottle or this Coke bottle is the product. It's actual, and if you hear the dog barking in the background, just ignore it. But the cola is the product, but the brand, Coke or Pepsi, actually gets its value from the trademark that's associated with it. And so what that trademark does is it allows Coke and Pepsi to distinguish themselves from each other. So it's a distinguishing feature of a product. Now, that does not mean that all trademark variations are the same. There's differences. So let's look at some examples and see how the trademarks differ between these different kinds of products. So the first one is the difference between the iPhone and an Android device, a Samsung device. So they're both smartphones, but they're very different products. They do basically the same thing. They have effectively the same functionality. They work as a phone, they browse the internet, they have apps, but they're different. They have different interfaces and different looks and feel. They have different features, but the product itself, the base product, is the same. The brand that's associated with the Apple device is different than the brand associated with the Samsung or whatever Android device, but the functionality is also different in some way. Okay, so we just already talked about Coke and Pepsi on the upper right-hand side of this slide. The cola that's inside the bottles, I have them again here, the cola bottles, is roughly the same, both carbonated cola beverage, but they have different tastes. And so consumers are going to prefer one product over another, in part because of the brand, but also in part because of the product differentiation. Same thing as with Apple and Android. And also going back to Apple and Android for a second, there's also a status element to brands. So there's some status in some cases to having an iPhone, and that is a higher status symbol than, say, having a Samsung Galaxy. But it also might be different in some other places. It could depend on culture. Now, if you look at the bottom 2 products, on the left you see Advil versus just generic ibuprofen. In that case, the product is exactly the same. It's chemically exactly the same. The only difference between Advil and the non-branded ibuprofen is the branding. Now, it's possible that the company behind Advil you might feel more comfortable buying Advil because you're more satisfied that the product is going to be produced correctly, whereas with the non-branded ibuprofen you don't know who made it. So there may be some differentiation in that way, but the product itself is exactly the same, which means that the only variation between the two is the branding, really, unless like I said, there's some minor variation. Same thing is true with sugar. So if you go to Safeway, there's C&H granulated sugar, and then there's Safeway Select. The product is exactly the same. It's exactly the same, but the Safeway brand is much cheaper. It's a commodity product that is branded. That's what C&H pure cane sugar is. So in those cases, in the bottom two cases, the brand accounts for much more of the difference between the products than it does in the two on the top. But even in the two on the top, it still accounts for some aspect of the brand variation. All right, so as part of our confinement for the coronavirus, we've been going on a walk with the dog most of the days. My daughter has been riding her unicycle, which she learned to do when she was in elementary school. That's been her form of exercise. And we had this discussion about the difference between regular M&Ms and fake M&Ms or non-branded M&Ms. And I'll let you watch this video from our recent walk. So tell me the story about the unbranded M&Ms. Are they the same as branded M&Ms?
Nope.
Why not?
They almost caused a union, like a mass walkout.
Why?
Employee mistreatment by putting unbranded M&Ms in the communal snack jar as a cost-saving measure.
And
I am worth more than plain wrapped M&Ms. Like, I am worth peanut M&Ms, honestly.
Sure? Now, what if they were unbranded peanut M&Ms? Would they be the same to you?
I would have had to quit.
And so, tell me, how many have been consumed? Have employees?
I think everyone at least tried them because they didn't know, and now they've been untouched for weeks.
So would you say that the money that the company spent on the free unbranded M&Ms is was it worth it?
They can never make it up to us.
So they lost. Not only did they get the cheap M&Ms, but now they have pissed off employees.
Right.
Wow, what you want to do?
Okay, so that goes to show that, at least in my wife's opinion, non-branded M&Ms just aren't the same product. So she's only going to buy products that say M&Ms on them, and that has value. So let's talk about this value from both a legal and an accounting perspective. All right, so what creates this value that we just got done talking about? Well, it's a massive investment on the part of companies like Apple and Samsung and Coke and Pepsi and Advil and C&H Sugar and M&Ms. All these companies spend enormous amounts of money promoting and advertising these brands, and that's where this value comes from. But it only is there because the trademark law permits it to exist. So absent the trademark law, absent that, they would have no way of protecting their brand and would have no incentive to invest in it in that way, in that same way. So what makes these brands valuable is the fact that these companies can enforce their brands using the law. Now, what's really interesting from an accounting perspective is that some of these companies whose value is largely driven by their brand, you will not find that brand anywhere on their balance sheet. If it's internally created, if it's an internally created brand, it is not on the balance sheet. So what does that mean by internally created? Well, you come up with the idea, you advertise and you promote. All of that advertising and promotion expense is expense. It doesn't go on the balance sheet as an investment, even though that is really what it is. But from an accounting perspective, those brands are not on the balance sheet. Now, if a company were to go out and buy another company, they could then put the value of what they're buying on their balance sheet. So you will see some companies will have the value of certain brands on their balance sheet, but not all of the brands. So only the brands that they acquire after the fact. Okay, so this leads us to our first key legal concept. So we're going to see how this works. Key legal concept. Okay, the first key legal concept that I want to talk about is this requirement to protect a trademark. So when you have one, after you've created it, you can't then just abandon it. And you can't fail or you can't allow counterfeiting to occur. If you're aware of counterfeiting and you don't work to stop it, or if you abandon your brand, then someone who is challenging your ownership of that brand can use that as a way to attack your ownership of it, and you can actually lose it. So it is possible to lose a trademark if you don't protect it, and if you're not aware of and don't stop counterfeiting. And so we saw this story of these Julia Child's dolls in the book, and I had to look it up because I thought, who would ever want a Julia Child look-alike doll? But apparently they do, because they exist, and I found this copy of it here, and I also looked up a picture of her so you could see she's even wearing the same outfit as the doll. So, but the point of this section is that you have to protect your trademark through protect it against counterfeiters, which are things that other people are doing, and you can't abandon it. Because if you do, someone else can take it and use it. Okay, which brings us to our second key legal concept. This is our second key legal concept. Okay. In this key legal concept, we're going to go through real quickly what trademarks are in general. All right, so a trademark at its core, and by the way, there's a whole class on this in law school, so this is not something that in 2 slides we're going to cover the whole thing. But it's important to understand what a trademark is. And a trademark is a distinctive mark, word, letter, number, or picture. And so big part of this is it has to be distinctive. So it has to be something that some consumer might ultimately associate with your product. So if you look at the pictures that I have on this slide, the Nike swoosh is doesn't mean anything. It didn't mean anything until Nike adopted it and invested the advertising and promotion in it. It's just a picture, it's just an image. Google is a word, so a made-up word, and in the next slide we'll talk about words. But Google is an example of a word that is a trademark associated with that company. The Major League Baseball logo is also just a picture, but we associate that with Major League Baseball. And there's actually some litigation with Major League Baseball over the ownership of the letters MLB. They've actually sued some companies that are using that sequence of letters. So a sequence of letters, an acronym, could also be a trademarked name or item. Okay, so Alaska Airlines, if you look at their logo on the left, they also have this picture of the Alaskan native that's on the tail of the airplanes. So that picture is also a trademark. The name is a trademark. The word Alaska is a trademark, and so is the picture. Now we're going to talk on the next slide about how can you possibly trademark the word Alaska. Well, in this case, they've trademarked Alaska Airlines, but they don't have an exclusive right to use the word Alaska. So somebody else could name their company Alaska, Alaska Toys or Alaska Furniture. And Alaska Airlines would not be able to prohibit somebody from using that name. Now, they could prohibit somebody from using the exact font that you have here, and in fact fonts are copyrightable, and in some cases the font is also trademarked, but you'll notice the way that the line comes across the A for Alaska. So you couldn't have Alaska Furniture Company and use this exact version of Alaska in this font exactly this way, because again, a consumer might be confused over whether it's a different company. I noticed I have on here the Susan G. Komen Foundation, and because I put that on there because they've actually sued companies over the use of the color of the particular shade of pink that is associated with their brand, and they claim to have the trademark on the use of that pink. And in fact, there's a lot of dispute. There's been some people who used to support the Susan G. Komen Foundation who've gone away from them because of their kind of aggressive litigation tactics. So W Hotels is an example of a company that has trademarked a letter. So they use W as their trademark, but it's W Hotels, and again the W is in a particular unique identifiable font. It's distinctive. Now you could call your company W Furniture if you wanted, and as long as it didn't look exactly like this, then it would be trademarkable. So it's all about consumer confusion. And then the last one, I thought, I was thinking about what company uses a number in their name, and it reminds me of, there's a bank in the Midwest called the Fifth Third Bank. It's like the weirdest name of a bank, but they do exist, and they're called the Fifth Third Bank, and so that's that logo you see there in the bottom right. Okay, so I kind of already mentioned words a little bit, but words are the value or the protection or the ease with which you can get a trademark based on a word differs by the kinds of words. So arbitrary made-up words like Google are the easiest to register and the easiest to protect, as long as they are unique and distinctive, as long as somebody else isn't already using them. The next strongest, or the next easiest to register, the next easiest to protect, is what we would call suggestive words. So the example that Shell gives is copper tone. Okay, those are common words; those aren't made-up words. But copper tone and copper and tone together suggest this idea of a suntan, and therefore it's considered a suggestive trademark. And those are next easiest to register and next easiest to protect against an infringer. The hardest trademark to get, the hardest trademark word to get, is something that's descriptive. And we talked a little bit about this already in the Alaska Airlines context. If you're just describing something as gold, something as soft, or as flexible, or whatever term that you use, if it's just describing some feature of the product, that is much harder to get trademarked. You have to have some association and some what we call secondary meaning. So their consumers have to associate that word, that descriptive word, with that product in some meaningful way before you can get a trademark on it. And then lastly, Shell talks about it a little bit, but family or common names, for the most part, you can use your own name without having to seek anybody's permission. But sometimes you have family members from the same family who are fighting each other over the use of the name. So there was a famous example of the Kellogg brothers getting in a fight over that. And in some cases, they have to either make changes to it or use variations of the name so that the companies can be distinguished, so the trademarks can be distinguished. Okay, so there are a few cases that are covered in this chapter, and those are Coke and Pepsi, which we talked about a little bit already in this video. Oh, and we just have the dog just came in to visit. Come here, Lulu. Why don't you come up here? All right, so this is the dog. This is Lulu, and so she's gonna make probably some more appearances in our videos, but you're not supposed to be down here, and you know that, right? Okay, what do you think about trademark? Are you gonna get a trademark to your name? Okay, probably not. So I'm gonna put her back. Can you call the dog? Lulu, go. Okay, so we've already talked about Coke and Pepsi, and in their case, their battle was over the use of the word cola. So Coke is actually called Coca-Cola, and so one of the strategies that Coke used in the early days to try to fight the growth of Pepsi was to argue that they had the exclusive right to use the word cola. Now, as a side note, Shell makes a really important point here about this settlement strategy. Coke had the opportunity to own Pepsi early on and didn't do it. Later on, realized their mistake in not settling, and they settled with Pepsi later after the litigation got expensive, and they just decided they were going to have a truce and not argue with each other over who gets to use the word cola. Windows and Lindos is kind of funny because in this case, Windows is a very descriptive term, but it does have clear secondary meaning and an enormous brand value. And in this case, they were able to leverage both their market position, their substantial resources to get a settlement out of Lindos. Lindos was a company that made a competing operating system. And that settlement, Lindos actually sold the name to Microsoft for, I think it was $20 million, and it actually continued on as a different company. I put here just to the right of that, this Canadian teenager. I always thought this was a funny story. His name is Mike Rowe, R-O-W-E, and he registered the domain name Mike Rowe Soft, and that was his website. And he got like a nasty cease and desist letter from Microsoft, and Microsoft went way overboard with him, arguing, of course, that they have this obligation to protect their trademark. But they probably went a little bit too far. Ultimately, the kid gave them the name, and they gave him an Xbox, and they called it a day. But the last case, which I think is an important lesson to learn, is where you take the pursuit of your trademark too far. And that's what Victoria's Secret did. They were fighting a very small regional store that sold adult items, and that named itself Victor's Little Secret, and they sued under the Trademark Dilution Act, which gives trademark owners the right to sue if somebody is diluting or devaluing their brand. And of course, this little adult toy shop was not doing that. There wasn't much consumer confusion or real dilution, but Victoria's Secret took it all the way up to the Supreme Court, and the Supreme Court ultimately ruled against them, and not only ruled against them, but made it more difficult to file those kinds of cases. So this is an example of fighting so hard that you actually made that strategy or the use of that law much different. Okay, so, and lastly, we have our last key legal concept, and this one is trademark dilution and famous marks. So I mentioned dilution already, that what that means is if somebody is like Victor's Little Secret, that could be said to be diluting the value of Victoria's Secret's brand. And there is this idea of famous brands, and famous brands have a special standing in trademark. So Nike is an example of a famous brand. We all know Nike. We all know what the swoosh means. And because it's a famous brand, it has the right to prohibit the use of that brand, even if it doesn't sell competing products. So the example I always use here is microwaves. So normally trademarks are associated with a category of product. And unless it's a famous brand, you can't prevent someone from using a similar mark on a completely different product, so long as there's not consumer confusion. But in the case of famous brands, like Nike, for example, everybody knows what Nike is. So if I were to produce a microwave and put the Nike swoosh on it, I would be prohibited from doing that because Nike is a famous brand and they have the right to prohibit dilution of their brand even in non-competing products. So that's the difference. That's what a famous mark is, and not all marks are considered famous, and it is up to the court ultimately to determine whether a mark is famous or not. Okay, so sorry for the slightly longer video this time. I think this is the longest one. I haven't looked yet at the time I'm recording this, but I think this is the longest one. If you have any questions, please post them in the forum. Any thoughts, please post them in the forum. And I look forward to seeing you in the next video. Thanks for watching.